Welcome to the Simplified Marketing Podcast. Straight talking ideas to grow your business.
Hello and welcome to the Simplified Marketing Podcast. This is another bonus episode for you. So during the week, we had an episode with Stephen Silverman of OGR Stock Denton. And here are a few of his thoughts specifically about mediation and what happens during a mediation. So let's go, just touching back on mediation. How do you, if you have two implacable enemies, let's say, or two differing opponents in a mediation, how do you get them to start to listen to each other?
Well, mediation is just a part of ADR, which is alternative dispute resolution. So you can either have a roundtable meeting where you go along and you don't have a mediator, and you can try to see if the solicitors can negotiate something with the clients there. But if you've got a situation where that you just don't think that's going to happen, so you have a mediation, and the mediator, I don't know if you know how mediation sort of the setup. But
if you explain it from
so you'll start off a mediation with, you may have sent position statements to the mediator as to what both parties are saying about the particular dispute.
So that's worked out beforehand. So everyone walking in the room understands or has an idea of
you definitely have an idea of what the other side are going to be saying. And then they may start off with an open session with the mediator, and both parties just have about 10 minutes just to set out what their position is and what they say. You don't have to have that, but that quite often happens. And if I've got my client with me, if it's a personal injury case particularly, and I want the other side to see my client, to know that she's going to be credible, and then I'll make sure that they're there, because it's a good opportunity for them to see the claimant and think, oh, my cracky, she looks pretty credible, this woman. Yeah. But you have to decide what you're going to do. Anyway, then the parties go into separate rooms, and what actually happens is you have three rooms. You have your room where you've got your legal team and your client. The defendants or claimants, normally the defendants when I do these matters, are on the other in their room, and they've got their legal team, and then there's the mediator. Or a breakout room where everyone can get together, or perhaps the barristers will just get together to have a little chat. And the mediator will go between the two rooms, and whatever is said in either room is absolutely privileged, and the mediator will not share what you say to him with the other party unless you authorise him to do so.
Okay.
So he will come to you and he will say, well, this is what they're saying, and you'll have some position, shuffling, whatever. And then you'll get to the stage where you normally start talking some figures. And
I was going to say, how soon does money start to come into?
Yes, you were saying what happens if you've got two parties who aren't going to talk. And I suppose the thing there is, it's for the mediator. The mediator may say to one, look, I know how you feel about this case, but there is risk of litigation, and there is something, do you not think there's something in what they're saying? Perhaps you should go back. So it's for the mediator to try to get the other person to mediate. Now, I mean, I have walked out of mediations where it's just clear that we're so far apart, it's not worth pursuing. So it does happen. But on the other hand, you can start some negotiations. And as to how quickly the money happens, well, I always make sure that the money does start happening by about lunchtime, because otherwise it's not fair on the client. Quite often with the personal injury client, you've got an individual, they get tired as well. Yeah. And I won't have them put under any pressure to settle. We can walk out about mediation. I don't want people settling and then thinking, I should have gone for more. So we normally got an indication before we go in of what our bottom lines are, or roughly where we are. We certainly would have had a valuation of the case from the barrister, etc.
And is it really as simple as if you see in all the different movies and films where someone writes a figure on a piece of paper and pushes it across the desk?
Eventually it gets to that.
Okay.
I mean, it's not that easy, because you have to base your figures on arguments. Yeah. But eventually, it depends how far you are apart. And then it does become horse trading a bit and trying to sort it out. Okay. And it depends on who's got what authorities. I mean, one of the things I always insist on, if it's a personal injury case or in case involving insurers, is that somebody's got authority in that room
to say yes.
Because I have had mediations where someone said, well, we haven't got authority to go beyond this figure. And we'll have to, and I just said, it's just a complete waste of time, And so I won't go to a mediation unless we know there's someone who's going to have authority there to really deal with it, or going to have someone on the end of the phone.
Yeah.
Yeah.
So the idea being then that everything can be sorted out there and then.
Oh yeah, I mean the idea really is to try and sort it out, and if you can get to an agreement, then you'll do the settlement agreement there and then, and it will be signed, and then you've reached your agreement. I mean, one of the things I should stress, and people are a bit concerned about mediation. Am I going to let the other side know where I'm coming from or whatever? Everything at the mediation is completely without prejudice. You cannot refer at all to the mediation at the trial unless someone starts really lying about certain things, But it's very rare that anything's that the mediation is referred to at all. And the judge actually isn't going to know that mediation has taken place until the end of the trial. And if any offers are made, those are completely privileged. And if you make an offer, you can make a Part 36 offer or various different offers. Again, the judge doesn't know that until the end of the trial when you deal with costs.
So would that compromise a ruling if that was
Yes, yes. If you put in a bundle before the judge and it's got without prejudice correspondence or with a Part 36 offer, and so the judge has seen that the claimant offered to take 20,000 when he's claiming 50,000, or whatever, it's just figures, then he won't be able to hear it. Yeah, he really won't be able to hear it because he's been influenced too much. So it has happened. I think there have been rare occasions when the judge has said, well, it really doesn't affect what I feel about it or something. But no, because you can make, I quite often will make an offer on liability with split liability 50-50. If you go to trial, it's winner takes all basically. But you don't want the judge to know how you're thinking about it. He's got to go with a fresh mind.
I quite like the amount of poker, if you like.
There is a lot of
playing your hand.
Yeah, there is a lot of playing your hand, and negotiations. You always have that, and with telephone negotiations with the other side, you sort of, I will always try to get the best result for my client and use every single argument I can. But
are we going to get a negotiation hints and tips now?
It's a personal way to do it. I think actually one thing, if you're going to negotiate any case, you have to have all the facts at your fingertips.
Okay.
Because when you're having a discussion and someone starts raising something, sometimes their arguments can be very logical, can sound very good, and you've got to know the point you can come back with. And that's where you really have to know all the facts.
So is there an essence of, I don't know, I'll put it bluntly, but an essence of laying a trap for the other side to walk into, which you can then...
I don't know so much about traps.
Or ask, in a way, incriminating themselves, or you have some... If they're going to give you a statement which you know to be not necessarily accurate, and you have evidence then that you can prove against it, but asking that leading question for them to...
Yeah, well, I mean, you can actually say in negotiations that, there's obviously a difference of opinion as far as this is concerned, but our client, we feel our client's going to stand up and be credible at trial, and also we don't know how your client's quite going to deal with this point, etc. So yeah, it all depends what it's case sensitive, really fact sensitive to how we deal with it.
What would be the number one point or number one piece of advice you would give someone in a negotiation?
Never have a discussion unless you're fully prepared for it.
So preparation is
everything. Preparation is key.
So thank you very much to Stephen. So don't forget, you can email into the show at hello@marketingsimplified.co.uk. If there's a topic you'd like us to cover, just let us know.
That's all for this time. But don't worry, we'll be back with more soon. Stay tuned for new episodes at marketingsimplified.co.uk.